Hi, everyone. My name is David Fulford, and I'm the CEO of IPAC, and it's my pleasure to welcome you all here today. I would like to kick off what is the fourth of our series in a webinar. Today, we're going to focus on exploring the themes behind rebuilding First Nations governance. But before I do that, I want to acknowledge that IPAC National Headquarters is on the traditional land of the Huron-Wendat and most recently the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and IPAC is grateful to have the opportunity to work on this land. We're pleased to have viewers joining us today from across Canada, and we hope that everyone will take an opportunity to acknowledge the traditional people of the land that you work and live on. And with that, let me pass it over to Catherine McCrory. Catherine is the project manager for the Rebuilding First Nations Governance Project, and she's our moderator for today. Catherine, over to you.
Thanks very much, David, and hello from unceded Algonquin territory here in Ottawa. I'm really pleased that you are all joining us today again. Hopefully, some of you are back from our previous panels, and for those of you who are here for the first time, welcome. Before we begin today, in lieu of an opening prayer, I would like to ask you to help open this session in a good way for us. An important practice in Indigenous communities across Canada before any gathering is to take a few moments in gratitude and in reflection on the many gifts that we enjoy on this earth, and to consider the responsibilities that all of us have to care for each other and for the land that sustains all of us. Our individual lives are made infinitely better by our friends, by our family, by our communities, and by broader society. And we have a reciprocal responsibility to make their lives better. All of us are here today in this session because we care about making life better for our people. Thank you for the many gifts that you bring to this work and the efforts that you're making to learn and to take action. I hope our discussion today will contribute in even a small way to refreshing and recharging you for the challenges that you and all of us face. So I'd just like to ask you to take a couple of moments in quiet reflection to settle our minds and open our ears and our hearts to our discussion today. So let's begin. I know I was refreshed and recharged by having the opportunity to have a pre-discussion with our expert panelists yesterday. I'm really pleased to present to you Satsan, once again, Naomi Metallic and Kent McNeil. For those of you who are here for the first time, Satsan is the co-director of our Rebuilding First Nations Governance Project, and he's a principal at the Center for First Nations Governance. Naomi Metallic is Schulich School of Law at Dalhousie University, and she holds the Chancellor's Chair in Aboriginal Law and Policy. And Kent McNeil is an Emeritus Distinguished Research Professor at Osgoode Law School. And in January, he's going to be taking on a Fulbright Canada Chair in International Area Studies with Yale University. Couldn't ask for, there are a few Canadians in Canada who can talk about the challenges in terms of Aboriginal law in Canada. And so I'm really pleased to have you all here, and you can read more about them on our website. So for those of you who've been following along, our last session was focused on Indian Act. And that's sort of the general conundrum of the fact that still after more than 150 years, the vast majority of First Nations governments on reserve are within the legislative framework of the Indian Act. And what do we do about that, and how do we get out from under it? So one of those tools that we have at our disposal is 40 years ago, when the Canadian Constitution was almost 40 years ago in 1982, when it was repatriated. After many years of struggle by Indigenous leaders, we have Section 35, which explicitly acknowledges the existence of Aboriginal and treaty rights in Canada including the inherent right of self-government. Since then, First Nations in particular have had the opportunity to enter into self-government agreements with Canada, to negotiate these and with the provinces and territories. We have a number of court cases that have also helped define the inherent right. But I think, when you think about the fact that it is almost 40 years of existence, we don't see as many examples of self-governing First Nations as perhaps we might have expected to see. And so one of our goals for discussion here is to really ask these experts, what can or needs to be done to galvanize implementation of the inherent right to self-government, and who shares in that responsibility to do so. As before, I'll be asking questions of each of our panelists in turn. There'll be an exchange with each other, of course. They don't agree on absolutely everything, as I learned yesterday, so that'll be fun. We'll give you an opportunity, of course, to ask questions of them towards the end of the session. We would ask that if you have a question for one or all of the panelists, that at the bottom of the screen, you'll see there's a chat box, and I see some of you already saying hello in the chat box, but there's also a Q&A box, and we'd really appreciate it if you'd put the Q's and A's in there, because it's a little bit easier for us to keep track of them. So I'm going to start with Satsan this morning. And Satsan, like many First Nations leaders before you, you've been working your whole life on the question of Aboriginal rights and title, and seeking recognition for those within Canada. In your view, why was Section 35 an important achievement, and what does it mean for us almost 40 years later?
Thank you very much, Catherine. And first of all, I want to welcome all the viewers who have taken time out of their busy schedules to join us today for a very, very important dialogue and opportunity to learn, think. But I thank you for the question, Catherine. I think we need to put it into perspective before we can realize just how important it is that we have Section 35 and that we've been able to define it to a certain degree. And I think the background to this is very, very essential to understanding not only the importance of the law and the Constitution, but why we went there and what our objectives were. There's no question in all of the First Nations across the country, we have a long, long history of being on our lands, exercising governmental authority of ourselves as a people in our territories. And we know what has happened as a result of settlement and colonization and confederation, and ultimately at confederation, the inclusion of Section 9124, now known what we know as the Indian Act, which basically separated us and excluded us from the rest of the Constitution. And as a result of that, our history of our inherent right to self-government in Canada is very, very important, not only for our own people to understand, but for the public to understand. Through the inclusion of Section 9124, the Indian Act, there was a serious diminishment and loss of jurisdiction across the country for all of our nations. We're pushed off of our lands to make way for settlement and colonization and confederation. We moved from our own economy. Our own governing systems were outlawed. Our ceremonies were outlawed. And they tried to destroy our worldview as a people, to take away our identity as a people. And the best indicator of that is, as we all know, the residential school experience. But having gone through all that and endured all of that, we have a legacy of resistance. as First Nations people across this land. And notwithstanding what has happened to us, we fought back. And we're still here today, still talking about it. And it's important to understand what we were fighting for and why, and what our objectives were. We tried every means possible. We tried negotiations, we tried the political route, we tried direct actions, occupying the land. We tried the court case, the court system. And ultimately, we weren't getting to where we needed to be, and our situation was worsening as time was going on. And so people made a decision, myself working with the Gitxsan and the Wet'suwet'en people, that we need to take the plunge, and we need to go, and we need to try to use their law to gain the recognition that we need in order to deal with our territories and our rights as a people, and to create a new relationship, which we always should have had with Canada. So we were practically forced into the courts. And our objective when we went there was, first of all, we need to be able to take care of our people once again. We need to rebuild the health and well-being of our people, regain our language, our culture, our customs, our traditions, our histories, our ceremonies, our complete identity. And we wanted to take back our place on our territory so that we can fulfill our obligations and responsibilities and use the lands once again to have our own economies and to protect it for future generations. We want to put back in place our own jurisdiction under our own laws, put back in place our own governments, our own governance systems, to once again to be able to use and look after the land and the resources, and to bring back a people that we need in order to accomplish all of this. So we're forced into the court, and we went there. A lot of our own people being very, very afraid. When we went into the court on Delgamuukw and Gisteway seeking a declaration of ownership and jurisdiction, there was fear amongst our leadership. We're asking for too much, you know. We're going into a foreign court, and how do we know what will result from that? But nevertheless, our people persisted, great vision, great leadership, and we pressed on. And through the effort, not only of the Gitxsan and Wet'suwet'en people, but other nations throughout our lands across this whole country, we went into the courts, we changed the law, we created new law, we brought about a recognition of Aboriginal title and treaty rights, including our inherent right to self-government. We changed the Constitution with the inclusion of Section 35, the existing Aboriginal and treaty right. That word existing was pushed by then Premier Lougheed. And the purpose for pushing for that word existing under Section 35 was their position of the Crown at the time was that there weren't any more existing Aboriginal or treaty rights. In other words, that they had been extinguished. And through our work in the courts, we know that we've gone from that empty box place to a full box of rights. And not only that, through our work in the courts, we've created the constitutional space for our jurisdiction under Section 35 and a new relationship with Canada, a nation to nation relationship. We've also created within the law and the Constitution a procedure to drive negotiations toward reconciliation And in the words of the court itself, a reconciliation between the pre-existing sovereignty of First Nations and the assumed sovereignty of the Crown. And the big challenge there is the law is not on the top of mine and the top of everybody else's mouth across the country. We have to learn. And the challenge for us within our own community is to teach our people that we've accomplished the recognition that we need. We've created the tools that we need to start to rebuild our nations and to fulfill the vision of our great leaders of the past. They set the path for us, and we're here now to pick up the tools and do the necessary work to rebuild our nations. The problem with it is that when we were creating the argument, for example, on Aboriginal title and rights, I brought that back to our chiefs and saying, so here's the argument. Imagine it's a ball. Does it match up to the ball as you see it from your perspective of what your title and rights mean? And of course it didn't, and it couldn't. But was it sufficient enough to put ourselves in that place where we could negotiate from a strong position and rebuild our nations? And one of the great things that I think we've accomplished, besides all of that recognition, is the fact that our rights are inherent. We always had them. They survived Confederation and are recognized and protected under Section 35 of the Constitution Act 1982. And we don't need to negotiate with anybody, and we don't need anybody's permission to do it. So the issue, Catherine, is that it's our responsibility to do. And it's a huge challenge. It's a big, big job, because we're practically starting from ground zero. Engaging our people, teaching our people, coming to common vision, establishing the priorities, rolling up our sleeves, putting the tools in our hands, and getting busy and rebuilding who we are as a nation. And with respect to those agreements that were negotiated in the past, most of those were done before we came out of the courts with the recognition that we've achieved. And some of the negotiations that are going on today, the mandates have not changed, consistent with the law and the Constitution. So the Crown has a long way to go. And ultimately, and I'll end here, because I think this is very, very important, we need to reconcile on the one hand with the Crown, Canada, the federal government and the provinces. But on the other hand, we also need to reconcile on the ground between the respective sovereignty holders. Those holders of our pre-existing sovereignty as Indigenous people, and those holders of the assumed sovereignty of the Crown. And when we can achieve that reconciliation, then the way I view this is that we can complete Confederation. So that's the way I look at this. I think that we've done enough to begin the work that we need to do. The recognition that we've gained through the courts and defining Section 35, if we use it properly, and I don't think we may, why should we have to go into the court again? You know, that just doesn't make any sense in this day and age. So the challenge is on First Nations to pick up and exercise their own responsibility. And we've got to overcome over 150 years of colonization and oppression under the Indian Act. So that's where we are. We've gained the recognition. So I'm looking forward to hearing from Kent McNeil and Naomi about how can we implement and breathe life into the rights that we have.
Thank you, Satsan. So I am going to invite Kent into the conversation here, who, maybe you have some reaction to some of the things that Satsan just laid out, and particularly wonder if you could help all of us understand a little bit better, particularly from a Canadian government or Crown point of view, what that the space that Section 35 creates, either in your view or in some of the court cases that have evolved over the period of time that we've had Section 35 in place.
Okay, well, thank you very much, Catherine, and hi, everyone. It's a pleasure for me to be on this panel with Satsan and Naomi. And really, I'd like to focus on some of the things that Satsan has already said and reinforce what he has said about the inherent Indigenous governance authority and Indigenous law and the application of Indigenous law. And talk about that more in the context of the Canadian legal system and the Canadian Constitution. So it's clear that Indigenous nations were sovereign prior to the assertion of sovereignty, both by France initially and then by Britain over what is now Canada. And the Supreme Court has acknowledged that actually on several occasions, starting with the Haida decision back in 2004. So this isn't new. And of course, for Indigenous people, they've always known this, but it's taken a while for the Canadian courts and for the government of Canada to finally acknowledge this. And that has happened. But as Satsan was saying, one of the challenges here is, well, how to implement that, how to make it real on the ground, and for Indigenous peoples to actually assert their sovereignty again, because the impact of the Indian Act, in particular, residential schools and so on, has seriously undermined Indigenous nations' ability to govern themselves and to exercise their own laws. Indigenous sovereignty, nonetheless, continued after colonization, it continued after Confederation, it continued in spite of the Indian Act. And Chief Justice McLaughlin, in a decision in 2001, the Mitchell case, so this is 20 years ago, said this, quote, Aboriginal interests and customary laws were presumed to survive the assertion of sovereignty. That's the sovereignty of the British Crown and then of the Canadian state. So the Supreme Court has acknowledged this. And there was also a decision from the BC Supreme Court. That's a trial judgment out of BC by Justice Wilkinson. Have I got that right? No, I don't think I do. Anyway, BC Supreme Court in 2000 in the Campbell decision. And that decision affirmed the inherent right of self-government in Canada, and it's never been overruled. So there are three orders of government in Canada. There's the federal government, of course, there are the provincial governments, and there are Indigenous governments. And for the federal and provincial governments, their powers, their legislative and governmental authority is set out in the original BNA Act from 1867. It's now called the Constitution Act 1867. And it's in sections 91 and 92 of the Act. So that lists the authority of the federal parliament and government on the one hand, and provincial governments and legislatures on the other. But it's very clear that that authority is not exhaustive. And as was said in the Campbell decision in 2000, there is and always has been room in the Canadian Constitution for a third order of government. That's the Indigenous governments. Then in 1982, as Satsan mentioned, Section 35 was added to the Constitution, recognizing and affirming the Aboriginal treaty rights of the Indigenous peoples in Canada. And what that section did was constitutionalized Aboriginal and treaty rights, including the inherent right to self-government and the application of Indigenous laws. So this meant that the third order of government that has always existed, but often been repressed by the Canadian state, became part of the Constitution. So what Section 35 does, in part, is provide this constitutional space for the third order of government. So it's constitutionalized it. That means that, federal parliament, provinces can no longer take away Aboriginal treaty rights. They have to negotiate with Indigenous peoples. And this has really been a major change in Canada. Part of the problem, though, is that Canadian governments, both provincial and federal, don't always acknowledge this reality. So it's been a struggle, as Satsan said, having to go to court to get the Supreme Court to weigh in and sort of push governments. And that's happened in a number of cases. Not all the Supreme Court decisions are that favorable. There's sometimes two steps forward, one step back, but nonetheless, there has been a lot of progress. And that progress has happened because Indigenous peoples have taken the initiative, have gone to court, made convincing arguments, and got favorable decisions from the Supreme Court. So how does one implement these inherent rights, in particular the inherent right to self-government and the application of Indigenous law? Well, again, as Satsan said, it's up to Indigenous nations to do this. Okay, the constitutional legal space is there for them to do it. But if they don't act, if Indigenous nations don't act and take control of their territories and their communities, then the Canadian government and provincial governments are going to retain their control and their laws will apply basically by default. So there's a responsibility here on Indigenous peoples to actually make self-government effective within their nations and on their territories. It's also up to the courts, as I said, to respect Indigenous inherent authority and laws. The courts have been more willing to acknowledge Indigenous law than they have been to acknowledge Indigenous governance authority. Okay, so they've been pretty vague on that. As I said, the Supreme Court has said that self-government and Indigenous sovereignty existed prior to colonization. They continued, but the Supreme Court has not given us much guidance on what that means. So I think that the courts have to provide stronger acknowledgement and step back as well, and I'm not going to say permit, but to again acknowledge this authority. As Satsan said, it's not a matter of Indigenous people needing the permission of courts or governments. The authority's there and can be exercised. The other thing that has to happen is for provinces and for the federal government to also step back and acknowledge Indigenous authority more fully. Now, this is happening, and Naomi may talk about this more, but for example, in the Bill C-92, which is the First Nation, Inuit, and Métis families Youth and Children Act. So this came into law, I think, just last year. And that act, in that act, Parliament itself acknowledged that Indigenous peoples have a right to self-government. It's an inherent right, and it applies in family matters, but they saying that's just one example of where it applies. So we're making some progress. The other area, which Naomi may talk about, is the UN Declaration on the Rights of Indigenous Peoples. And Canada and the province of BC, through legislation, have said that they're going to implement the UN Declaration. So I'll leave it there and pass it over to Naomi, because I'm sure she can expand more on these and other issues. Thank you.
Thanks very much, Kent. So yes, Naomi, your turn for comments on anything you've heard so far, but also on the question of UNDRIP, the United Nations Declaration. Sasan talked about how this is going to be hard work to implement and reclaim law making in Indigenous communities, and Kent kind of reiterated that. I know there's some conversation out there saying, actually, UNDRIP will make it all much easier, and it's a bit of a magic bullet. So I wonder if you could sort of address the hard work question and the influence that UNDRIP may or may not have on galvanizing more self-government expression.
Great. Walali Oak, or Walal Catherine for that. And thank you for once again having me as a panelist. I hope people aren't sick of me. And I see all the people commenting on the chat where they are in their territory. So I'm in Mi'kma'ki, I'm in Esquigawagik, Chibuktuk to be specific, so in Halifax. So hello, everyone. Right now, so to this question about whether the UN Declaration is a magic bullet. Nothing is a magic bullet. But on the other hand, I do believe it is a very helpful tool to address some of the challenges we have had over the years with Section 35. In terms of, Satsan was talking about sort of our perspective of what Section 35 is, sometimes hasn't always aligned with what either the courts or the government, the federal and provincial governments have seen what Section 35 is. And I actually think the UN Declaration is a helpful tool to align that much more closely with the Indigenous perspective of, what is Section 35, and can help make it a much fuller and robust box of rights. Because, Section 35, the wording of it is quite broad. It says the Aboriginal and treaty rights of the Aboriginal people of Canada are hereby recognized and affirmed. And so the question's always been, what does that mean? And it's largely, aside from some agreements, as Satsan noted, mostly been interpreted by the courts, but interpretations can change. We've also in Canada recognized that our Constitution is a living tree. It grows, especially when you've got kind of broadly worded provisions. That interpretation can change over time. And so the UN Declaration can be a basis to help that evolution grow. The hope is that it can lead to this, I think. And I think it can do it in a couple of different ways. One is, I think it helps, and it's been mentioned a couple of times already, there has been a lack of political will to interpret Section 35. There have been some agreements, but beyond that, government hasn't robustly embraced that. There are other ways that government can do it. I mean, agreements are good, and the importance of treaties should not be undermined, of course. But there's other things that governments can do. They can pass policies and laws to also accommodate, make space. And so in some ways, Kent said step back, but sometimes it's by passing laws that create space and provide support and a clarity about how Indigenous rights will be accommodated and supported, not giving permission, but creating space can be very, very helpful. So in some ways, I think this new act, as well as the UN Declaration, actually pushes politicians to do more than they have before. I would argue that to a large extent, over the last 40 years with Section 35, politicians have largely abdicated their role, the importance of their role, to the courts. And I think now there's governments are seeing that they have a more active role to play in supporting, not exploiting or suppressing, but supporting the exercise of our inherent rights. And I also, again, think that the UN Declaration, like I say, will provide a broader box and a more robust box. First of all, it sets out comprehensively. It's got 46 articles, many of which have subsections, and touches on virtually every area of Indigenous peoples' rights, from education to health to spirituality to land, to consultation and free and prior informed consent and self-determination. So much is in there. And it also sets out quite specifically the role, the expectations on governments, what governments are supposed to do in order to implement this. And we've never really had that before. We've had the concept of fiduciary duty and honor of the crown, but they've been sort of sometimes a bit, vague, and sometimes in how the courts have approached them. And even though we have a clear idea of what that means, but this document actually says states shall take active measures to do X or Y. States shall take special measures. States shall consult to achieve free, prior, informed consent. So very specific obligations on the government are spelled out now that were never spelled out before. So it's a lot more clarity. I think that will be helpful. The fact that, now there is legislation that is saying government has to produce a plan to implement. There was never anything like that for Section 35. So we do have now actually something that we can hold government's feet to the fire on. You have to implement it. And there's specific language in there about what they have to do. And there has to be a dispute resolution mechanism. So there's a lot more to hold government accountable and prevent that lack of political will from taking hold. I also think one thing that is absolutely great about the UN Declaration, as well as the legislation, is underlining that these that Section 35 rights, that Indigenous rights, are fundamental human rights, and they're general rights that all Indigenous people have a right to. And this goes further than I think some of the Supreme Court of Canada cases, which have said, well, they're kind of different from universal rights, and they have to be proven on a specific case-by-case basis, at least before the courts. But here you've got this statement that these are actually the fundamental rights that all Indigenous peoples across the world are entitled to as on a general basis. So I think that that's going to change how we see and how the courts approach Section 35. Again, I think it's breathing new life. It has the potential to really breathe new life into the Constitution. And I also think that it's going to strengthen our constitutional roots, because as both Satsan and Kent have said, the inherent rights were and our legal systems were the first legal orders here. They are part of our Constitution, as are our treaties, and they haven't received the amount of recognition that they should for that. And they became part of the common law, as Kent said. But I think the UN Declaration will help us to give more prominence to Indigenous jurisdiction, to Indigenous institutions and laws, because self-determination and self-government are really the cornerstone of the Declaration. You can connect so many of the specific provisions back to the right to self-determination. And beyond that, many of the articles really mention the role that Indigenous institutions and Indigenous laws have to play in the implementation of rights. So I think that's to answer some of your parts about the good that I think this, or the possibility, but it's a tool. All tools take work. Somebody's got to yield that tool, and somebody's got to push that tool, and it's going to take work. It's not like this thing got passed and like we live in a utopia today. We have all been steeping in the tea of colonialism for over 150 years, right? So, and I think governments are going to screw up. They're going to adopt probably narrower interpretations than they should. And saying that they're still implementing UNDRIP, and we're going to have to push them. So advocates and allies are going to have to use the tools that are available, maybe sometimes the court, but I think there's, public opinion and direct action and other things too can also help push and move the envelope. And so I think that that's all going to be work. And I think there's also work that our Indigenous governments have to play here too, and also implementing. So John Burroughs has made strong arguments, as have others, that there's a role for Indigenous governments to play in implementing the UN Declaration. And Sagej Henderson has said, that was actually the leading reason why so many people who were involved in negotiating the UN Declaration from the Indigenous side really wanted it to be about, refinding our laws, our worldviews, our humanity, and the things about roles of the government were sort of secondary to that. So there is a real role, I think, in us embracing, in the same way that Satsan and Kent were saying, seeing this as a great opportunity for us to rebuild, to revitalize. And there's some amazing work, if I can just finish on this point, happening. And for the last decade or so, there's been some wonderful work happening in communities and also in some universities with some Indigenous scholars who are looking at how we can reclaim and revitalize our laws and institutions. And they're looking at things like our stories, our languages, our ceremonies, and how we can look at those things and find our worldviews, our values, and our principles, right, that our ancestors lived by for centuries, and start to have conversations about how those things can influence and should influence the development of our laws and institutions today. So I am always a very hopeful person by nature, but I do think that there's, we can embrace these things, and we've got some good tools to work with.
Thank you very much. Before, we're getting some really interesting questions building here on the chart, but just before we move to those, each of you have talked about the hard work that needs to happen and who has to do the work. Maybe just a little bit more clarity on what that work is. And Natalie, you were just finished, or Naomi, sorry, you were just finishing with examples where people are starting to sort of reclaim their traditional laws and starting to rebuild or laws for a modern era based on traditional principles and values. But is that, I guess, are we starting to see examples of that happening across the country? What other work needs to go along with that? And what are perhaps some of the implications or concerns of First Nations or Indigenous people in generally starting to aggressively take that space for themselves? So Satsan, I mean, you're the one who's been thinking longest about kind of that body of work under rebuilding First Nations government. So maybe we can start with you, but I'd really like to hear from both Naomi and Kent on that.
Sure, thank you very much, Catherine, and thank you, Naomi and Kent. I was furiously writing notes as you were speaking because I think it's always important for us to, in this work that we're trying to accomplish, to always have an open mind and learn, continue to learn, because that can only serve us in the end. But what I've learned working in our community, and I first went out there after we came out of the Supreme Court of Canada on Delgamuukw in Gisteway, December 11th, 1997, I made the assumption that all of our people understand what Aboriginal title and treaty rights are and what it means to them, and the inherent right to self-government. And after several years of being out there in over 240 communities across the country, one day realizing, where are all the people? How come we're not all out here? And I realized that the assumption I was making was wrong, referring back to a paper that we had commissioned from John Burroughs, using our own law to get out of the Indian Act. And he looked back on his own family and said, how long has this affected us? and he realized that he was the 6th generation and that his children were the 7th generation. So I had to rethink my approach. I took some time off and went back. And I went back to the communities to be a teacher. We need to teach our people about what the inherent right to self-government means and why it's important to us. So we came up with a process, first of all, to bring our people together, activate collective memory. Language became so important and crucial to talk about what was our inherent right to self-government prior to the first settlers arriving on our territories. And everywhere I've been across the country, people remember when that happened because it has had such a devastating effect on them. What was your inherent right to self-government as a people? In other words, who were you as a people? What about your territories? What about your jurisdiction and laws? What about your governance systems and your institutions? What about resources, both in terms of people and lands and resources? So the idea was there to get people to self-define what their inherent right to self-government was. And then to take them to look at what, the history of your inherent right to self-government in Canada and the origin and content of the Indian Act, basically. So that the people for the first time can learn just what the Indian Act was designed to do, which was basically to exterminate our people. That was the stated policy objective, and the advertised objective became assimilation. Residential school was at the heart of that. So we take our people, we teach them about the Indian Act, where they learn for the first time that under the Indian Act, we are wards of the Crown, without legal status and capacity as a natural person, which every other Canadian is born with. That we don't own these reserve lands that we live on, that we have lost our jurisdiction, and so on. And then to teach our people about the legacy of resistance. And when we get there, every one of our people can go back into their own immediate family, and they can identify people and leaders who were part of that resistance and why. And then we teach them about the fact that we were forced into the courts, which we are talking about today. We changed the Constitution. We added Section 35. We defined it from an empty box to a full box. We've achieved the recognition of our Aboriginal title and rights and our treaty rights and our inherent right to self-government. And then now we can rebuild who we are. And what happens when we get to that place in the community, and we had discussed this yesterday on our preparation call, I believe Naomi, you brought it up. The first thing that comes from our people is they have a sense of hope. That's what we hear. Thank you for giving us hope. And what comes along with that is you see this sense of empowerment, like just people starting to stand up, lift up their heads, realizing we can do something about this. And it's quite amazing to see and to witness. And I think that that's the challenge, is to overcome the fact of the Indian Act. With, if you look at the Indian Act, there's not one word in the Indian Act that says that the chief and council have to be accountable to the people. And consequently, they haven't been. And the babies being born today are the 8th generation under the Indian Act. So we've forgotten how to come together as a people with mutual recognition and respect for one another. And through this work that we've been doing in our community, that's the first thing we try to do, is to bring our people so that we can have recognition and respect for one another in order to have the necessary dialogue to create hope and to empower each other, and then to take action, to pick up the tools and get to work. So it's a huge educational effort, and it's a huge challenge, because one of the big things our people first have to overcome is the fear that, given the Indian Act has oppressed us and suppressed us to the degree that it has, living a sustenance lifestyle. We know through our research that as far as essential services are concerned, Indians on the reserve receive 45% less than the Canadian public has gotten used to. Resources and revenue raised off of our lands. And people are afraid that we're going to lose something. And we have to teach our people that comparable level of essential service is a constitutionally guaranteed to all Canadians. And we need to put ourselves there. And we need to put ourselves in that fiscal relationship with Canada. So it's a huge educational effort, and it's a huge organizational effort. And I think that it may take us generations to complete and to be successful. Be 8 generations today under the Indian Act. It might take us as many generations to get out of it. But I have big hope for the future, when I see that arising in the community, the way I interpret it, the way I see it, that's big medicine. So that's my take on it,
Thank you, Satsan. Well, maybe I'm going to shift the question a little bit for the other two. What hope do you see in terms of the spaces that we have to work in right now, and what people are actually doing on the ground? Naomi, either one of you want to start?
Naomi, go ahead.
Okay, sure. And so I'm thinking about how this project that we're involved in, the transitioning from an Indian Act self-government. One of the things that we're looking at is also there is work happening right now, not enough of it, but I think we will be picking up steam in a variety of different ways to do even more of this work. But kind of picking up on Satsan's point, I think if communities can see what other communities are doing, and it can just sort of expand our imagination about what is possible. There is some cool stuff that's been happening in pockets here and there. I'm gonna tout my own community of Listigoch, but I'm very proud of the different work that we've done. We have done a lot in terms of fisheries over the years. And some of that was, as a result of direct action and conflict with other governments, but then taking a very strong stand in managing our fisheries, and even more recently, because of some sort of, responding to how Canada was not appropriately managing the fisheries, and putting forward their own lobster law, and that that was after extensive consultation in the community, and developing a law that creates a lobster board who oversees the act and advises the chief and council, that are made up of community members from a variety of perspectives, and guided by a set of 4 or 5 different Mi'kmaq principles set out in the act that are that guide the entire application of the act, including the enforcement of it. And so very much steeped in Mi'kmaq values. And there are other examples of this, and I think a part of it is sharing this knowledge and this work. There's stuff going on throughout the country. That was just one little example, but there's so much more that could be done. And so, yeah, it's sharing that and helping our community members see that what we're capable of. I think it will also, a side effect is also help educating non-Indigenous people that we are certainly capable of all this, and we have the power and authority to do it. So yeah, It's just one example, Catherine, but it is possible for sure. And
Okay.
hopefully that was a nice example.
Yeah,
I'll
great.
just jump
Thanks.
in.
Sure.
Jump in here with on the point that Naomi made, because it's one of the most important things. And that is the fact that when we go to the communities, they think that they're worse off than everybody else because of the isolation that's been imposed upon them by the Indian Act. And when we teach them that the same system affected us all the same way right across this country, that's a revelation to a lot of our people. But the other thing that's important that Naomi just mentioned, and I think it's going to be the key to our success, is we have to learn from one another, and we have to work together, and we need to network. And so I wanted to jump in on that, Naomi, because I think that that's one of the key things that I've learned on the ground is the importance of that.
Thanks. Kent, give you an opportunity to jump in here.
Yeah, well, briefly, I think Naomi's example was excellent, and that people need to be learning from other communities and what they're doing. And that will provide, guidance and help, I am sure. I don't really have anything other to add, other than to say that it's not up to non-Indigenous governments, courts, or non-Indigenous academics, such as myself, to sort of tell Indigenous peoples how they should be implementing their own government's rights and their own authority. I can talk about the space in the Canadian Constitution and law for Indigenous governance, but it is up to Indigenous peoples themselves to actualize their governments and laws in accordance with their own customs, traditions, and worldviews. So I think, we need to, non-Indigenous Canadians need to support and acknowledge that authority, but step back and acknowledge that Indigenous peoples have to implement this themselves. And as Naomi was saying, it can be, through help from governments, it can be through funding, it can be through providing constitutional space and legislative space for these things to happen. But the initiative for actually doing it is going to have to come from Indigenous peoples, I think.
Great. I'm looking at all of the questions that have popped up and trying to think of a way to. Oh, sorry. Go ahead.
Yeah, just before we get there, I think just to put the notion of the reconciliation that we're looking for here into context. I mean, Kent referred to the fact that, and Naomi also spoke to it, about the fact that we're in this position of the third order of government, and the legal and constitutional procedure to drive negotiations towards reconciliation, as I mentioned earlier, is between the pre-existing sovereignty of First Nations and the assumed sovereignty of the Crown. So that reconciliation is jurisdictional. In other words, we need to move out from Section 9124 of the Indian Act under our own governance, under Section 35, under our own law. And when we get to our community to talk about that, as we mentioned yesterday, Naomi, the language becomes critical and crucial. People coming together to activate collective memory and working together. And then the most important thing that we've learned from our elders and people is the foundation of our laws has to be built upon our principles and values. So that's really important to know and to understand, that in order to have that reconciliation, it won't happen unless and until we put ourselves there. But we need to do it from the perspective of our own law, and we've come a long way. Delgamuukw and Gislewe, when our great leaders and chiefs of the Gitxsan and the Wet'suwet'en Nation argued that, first of all, our title and rights comes from our own law, the Chief Justice of the Supreme Court at the time, Alan McEachran, said that we weren't sufficiently civilized enough to really have laws. At best, they were customs. So we've taken the court from that place to Chilcotin, where the Supreme Court is saying that there's now a dual perspective. It's no longer just the common law, it's also the Aboriginal perspective, which includes our own law. So that's where it needs to happen.
Okay. Looking at the questions, and I think it follows on from your last points, Satsan. One of the common threads throughout, or one of the sort of common underlying questions, is how do you make this transition from the Indian Act conundrum, where you have chief and council governance structures imposed by the Indian Act and by the Crown, to self-governing institutions where, with a legitimate authority conveyed by the rights holders. And so what is that sort of transition space from Indian Act Band Council, who aren't really in a position to make decisions and act on behalf of the rights holders, to a world where, so you talked about community engagement. Naomi, you gave the example in Listugush of, that was created presumably through the chief and council structure, but with a lot of community engagement. What are some of the kind of fundamental things that people have to think about as they're starting to create their own laws, reassert their inherent rights, and so on and so forth? I know you have a point of view, Sets. Maybe I'll let Naomi get in first.
I mean, that's
Okay.
the conundrum, right?
Yeah.
On the one hand, we've got this recognition and law and a constitution sufficient, in my opinion, my belief, to get us there. And on the other hand, we remain stuck and mired under the Indian Act. So just our experience on the ground again, and that's where we spend our time, is teaching our people. And when we teach our people about the origin and content of the Indian Act, what always comes from it is a consensus decision for change. And in the absence of teaching our people so that they can make an informed decision for change, it's not going to happen. So that education is critical and crucial. We can't have a transition until we've built a consensus decision for change. And that's the first step in the process. And in my experience, it's also the toughest, because the Indian Act has just created so much conflict in our community amongst families, brothers and sisters, and so on. So the reconciliation, the first reconciliation that needs to take place, is amongst and between our own people. But what I've learned is, once you get that consensus decision for change, and people take off that Indian Act hat and put on their own inherent rights robe, their own inherent rights hat, the whole mentality and of course the mental models change. So that's where we need to get to. That's the challenge for transition. The first challenge. Of course, there are lots of other things. We got to bring back our laws. We got to bring back our governance systems and structures and institutions, and we got to put back our people in place. And it's a huge job.
Naomi?
I have too much to add to that. I guess my thought is that we are seeing, we are very resilient people, and so we've always found ways to subvert things too. And there have been, communities who have been, trying to figure out, even still under the framework of the Indian Act, ways to do things different that involve more community, that it's not just the band council system, or bringing into it other threads, hereditary leadership that are also informing, or working not just within a band system, but like here in Nova Scotia, we have the Assembly of Nova Scotia, Mi'kmaq, and we see this across the country, but working together, creating their own form of how they want to respond to things, and it informed, sometimes by traditional structures as well, and sometimes more modern structures. But there are ways that this are happening. Like I fear that we said like, oh, there's going to be a moment in time where it's just going to flip, the switch is going to flip. But we're doing some of this already, and I think so. A lot of it is sharing that information, sharing the ingenuity with which communities are starting to do things. Like there's one community that I know of that's looking at developing an internal process around consultation to make sure that all the grassroots and all the community is on board before chief and council can go, yeah, we're cool with this project, or we're not cool with this project, right? So there's stuff happening, and it's just, I think, getting that information out there. And I think for a lot of communities, unless you sign like a major land claim or self-government agreement, which, a lot of people are at tables to do, but they take a really long time, it's going to be sort of these gradual sort of little tweaking and changing, and at some point it's not the Indian Act system anymore, right? And so I think that this is happening sort of at an organic level, and we need to kind of embrace that as well, and try to help even push beyond the boundaries even more.
And that's the ultimate irony, like working in the community is the status quo is the Indian Act and the Band Council. That's not going to go away anytime soon. As Naomi says, we can't flip a switch. I'd like to, but that it is there. But what's common on the nation rebuilding project that we've got going across the country, those nations who are a part of it, leaders have made a decision that they need to transition out from under the Indian Act to inherent rights governance. And the ultimate irony is sometimes it comes in the form of a band council resolution. A band council resolution, which is recognizing the people who make up the nation as the inherent rights holders. And also saying that as a band council under the Indian Act, we aren't a rights holding body. So in effect, surrendering to their nation as a people. So that's something, and it's the ultimate irony, but that's what happens. And then you see those people moving from the band office because they are also citizens of that nation. So I guess the point there is it also takes leadership.
A whole other long discussion for another day. You might have heard my timer go off. I've let the time get away on us a bit, and I know people have other commitments at the top of the hour. So sadly, although it feels like we only just got rolling here, I'm going to have to wrap up this discussion for today. Starting by thanking all of you, and particularly Kent and Naomi for, and we're always happy to have you back, Naomi. I'll keep asking, to have your expertise and your thoughts and your examples to share with us. Very illuminating, and judging by the conversations going on and the number of Q's and A's we had, this is a topic we could probably come back to in more depth at another time. For folks to know, we've got one last in our series coming up on November 17th. This one will actually be kind of about, next steps. Once you've reached that consensus for change that Satsan talked about, what are some of the practical steps that communities can start to take to build a plan for implementing their inherent rights. So you'll want to come back for that. Just a reminder that all of our sessions are recorded and available on our website a few days afterwards. If you want to rewatch anything, or tell your friends and family to have a look. And I'll just close by reminding everyone that September 30th is the first National Day for Truth and Reconciliation. And in some jurisdictions, it will mean the day off for people, in others not, but we're encouraging all of you to take some time in the day for reflection and for discussion. And there are lots and lots of resources out there available to people to have the most basic chats to some of the more difficult and challenging ones like the one we had today. So I hope you will take the time to do that. So thanks again, everyone, and we'll see you back in November. Bye-bye.
Thank you. Thank you very much, everybody.
Bye, everyone.